I'm Scott Lachlan. This is the Data Chronicles, and here are your data points. In today's episode, we continue our global look at how courts and regulators are responding to legal issues associated with artificial intelligence. Not in theory, but in practice. What have we actually seen over the course of 2025 and the first part of 2026 in this key area? As a reminder, this is the second installment in a three-part series examining AI-related enforcement actions and litigation across key jurisdictions. In our first episode, we focused on intellectual property litigation in the United States, where creators, developers, and platforms are already testing the boundaries of existing law. In a future episode, we'll turn back to the United States and look more broadly at AI-driven enforcement and litigation trends. And you all may even be able to convince me to do a four-part series to try to cover AI litigation in IP in Europe and elsewhere. But today, I want to shift our lens to Europe. Across the UK and the EU, regulators and courts are moving aggressively and sometimes unevenly to apply existing legal frameworks to rapidly evolving AI technologies. Enforcement authorities are relying on areas like data protection, consumer protection, competition, and product liability regimes that were frankly not designed for large-scale machine learning. At the same time, litigants are beginning to test novel theories of harm tied to automated decision-making, model training, and AI-driven outputs. So on this episode, I want to explore some key themes. How are the UK and the EU regulators approaching AI-related enforcement using these existing legal authorities? And importantly, what is the role of the GDPR, consumer protection law, and the emerging AI legislation like the AI Act in shaping enforcement priorities? And what can these developments signal for organizations operating globally well beyond Europe? To discuss the current state of affairs for AI-oriented enforcement and litigation in the UK and the EU, I'm joined by two of my partners, Eduardo Eusteron from our London office and Julia Marios from our Milan office. Eduardo and Julia work closely with clients navigating UK and European regulatory risk, cross-border investigations, and complex AI governance issues. Eduardo, Julia, welcome to the podcast.
Thank you very much.
Thank you, Scott. Happy to be here.
Well, Eduardo, maybe I can ask you to get us started because, as many of us who are working in this space know that one of the challenges with artificial intelligence is that when people ask about, well, what are the AI laws? It's almost impossible to answer that question because there's not at the moment a single AI law. There probably never will be. AI is a piece of technology like an automobile that is subject to many, many laws, both new and existing laws. And we've talked about that issue on some of the prior podcasts, but enforcement continues. And even in advance of necessarily enforceable AI laws, regulators, courts are enforcing existing laws on AI technology. How do you see that maybe in a big picture playing out in Europe?
Well, the big picture is a picture that perhaps we are all familiar with, because, as you're rightly saying, enforcement is based on existing laws, laws that all of us are familiar with because we've been dealing with them for many years, particularly when we're talking about data protection and privacy laws. But of course, they are being applied to this new technology, new and evolving technology, in ways that are basically looking at how these provisions that we deal with daily are interpreted in this specific context of the development or the use of AI. And what we have seen in terms of the enforcement, which has been quite varied in Europe and even outside Europe, is that regulators tend to link the law and AI, but also another issue. So you have, aside from the enforcement that touches on the development of AI, when it comes to the use of AI, what regulators are saying is essentially, okay, how does this company comply with, say, data protection law in the context of AI and biometrics, or AI and international data transfers, or AI and children? So the kind of sensitive issues that we have seen emerging over the past few years are directly linked to the use of AI. And that's very much a trend that we are seeing again in Europe, including certainly the UK, but also other jurisdictions.
Yeah, and if I can add something on what Eduardo said, I think, this question comes up very, very timely, Scott, because we have been seeing a lot of hype around proper AI regulation, right? The AI Act or other pieces of legislation that country around the world are adopting in this race to AI regulations. But enforcement of AI under existing legislations, think about IP and AI or competition law and AI, and as Eduardo just said, data protection and AI, is already ripe. So we have seen growing and consistent enforcement actions over the past 3, 4, 5 years. And I think, these kind of links to an existential dilemma we are seeing reflecting about, especially in Europe in these last months, also with the European Digital Omnibus on AI, which is, do we really need to regulate in a sectoral vertical way AI? So I remember when the AI Act came together, there was someone that was provocatorily saying, nobody ever thought about regulating in a sectoral way software. Why should we do this with AI? As you correctly said, AI is by definition agnostic. So it's already the main issues around AI and its regulator are already addressed by existing pieces of regulation. But it's certainly interesting, I believe, to deep dive on the trends we're seeing with regards to data processing and AI enforcement, because we can learn a lot of what regulators are thinking about these new technologies.
And that's a really good and important point that you both made. And Julia, maybe just to kind of follow on what you were saying, one of the ironies here is that in many ways, AI is designed to make things more simple, to bring a lot of complex tasks and turn those into things that are repeatable and that don't require, then get rid of some of the complexity. I think in the way that AI is being regulated and being legislated around, it's quite the opposite. It's just resulted in more complexity, given the overlay between what existing laws would require, what we perhaps want for our AI regulation going forward, and then importantly, what are the many, many stakeholders that view how AI is going to be implemented and the way that it should be implemented, which at bottom really goes to some core themes, surrounding kind of what does the role of technology versus humans, what is the role of innovation versus kind of protections of individual freedoms. So many like core issues that many people have very strong and opposite feelings about. So with that, maybe we'll start to kind of to think about the different themes that we're seeing. And maybe Julia, I'll ask you first. The first thing I think both of you mentioned was around AI and data protection. So we have the GDPR in place and, widely considered the gold standard with respect to comprehensive data protection law in the world. AI uses data, uses personal data, uses all sorts of different types of data in connection with its processing. And my guess is that the GDPR is going to speak to AI. How do you see regulators approaching AI under the GDPR, and where do you see any types of enforcement themes coming to bear?
Yeah, I think it's really interesting because if we look at I would say the last 3 years, right? The first enforcement actions, especially against generative AI, started around 3 years ago. And I think there's really been an evolution with regards to the relevant topics and the relevant issues that are addressed by regulators. So I remember 3 years ago when there were the first enforcement actions, we were kind of shocked, I think, in the privacy community and there's certain irony, because on the one end, obviously data processing is part of the development of, almost all AI technologies, and especially generative AI technologies. But then when certain challenges and issues came up, like, is the collection and processing of data carried out via web scraping, does this amount to proper data processing that needs to fulfill all the requirements under the GDPR? I remember we had extensive debates on that, because up to that point, nobody really thought about that, right? There was some case law regarding to search engines that was kind of providing different openings. And then I think over the years, we have seen regulators, starting from the Italian Data Protection Authority that has been super active in this regard, kind of raising the bar. So really requesting, AI developers, AI providers to meet all the requirements under the GDPR, no matter what, in terms of transparency, data subject rights enforcement, accountability, and so on. So I believe what, 3 years ago seemed to be kind of, this is something I really always tell our clients, right? So 3 years ago, you could have a doubt on whether you had to have an information notice specific on data processing related to AI training. Now, this is considered to be the basics by, I would say, any regulator in the EU. It's a no-brainer. At the same time, what I'm also seeing is kind of different approaches. So we are seeing some regulators, starting from the Italian DPA, that are taking a very hard stance, enforcing in a very specific ways all these requirements and not providing business-friendly guidance. So just kind of going very harsh on, controlling and monitoring what the relevant players are doing. Whereas I'm seeing other regulators, such as the CNIL in France, that is trying to provide openings, right? And try to interpret the legislation in a way that is adapting and taking into account the challenges arising from the rise of these new technologies. Because even with regard to the GDPR, if you think about that, as technology neutral as it may have been conceived, it is still a piece of legislation that has been drafted more than 10 years ago. And there are certain loopholes. There are certain loopholes that need to be addressed with a kind of creative and, I would say, approach that takes into account all the relevant issues. And the proposed modifications included in the digital omnibus on data is just a confirmation that even the legislator is trying to move in that direction, right? So give more certainty and just provide solutions based on the lesson learned from these uncertainties that players had to face in the last few years.
Yeah, I mean, it's really fascinating. And maybe, Eduardo, I'm interested in one of the things that Julia had mentioned, which was, that this area around how the GDPR should apply to AI is kind of a central component of even debate on the continent and within the UK. So while the GDPR was designed to bring consistency across the way that all of the member states and the UK have approached privacy and data protection legislation, that doesn't mean that everybody has the same views about what it actually requires, especially when you start to apply it as something as important and as dynamic as AI. How are you seeing the different DPAs across the community start to approach the application of existing laws like the GDPR to AI?
John, what we have seen is a mix of approaches, in the sense that typically you see the bad cop approach and the good cop approach, sometimes by the same regulators. And obviously some regulators are perhaps more fond of one than the other. But if you look at, for example, the ICO has been quite harsh in some respects, and some people will say rightly so. But ultimately, the ICO is typically seen as this friendly regulator who is looking at how to support innovation and so on. So many people would say, okay, well, the ICO is not really going to be enforcing the law and the GDPR in connection with AI. Well, the ICO has even imposed fines for the use of personal data in the context of AI. And there was a fine, for example, against Clearview AI that linked this idea of collecting biometric data, so basically photographs of individuals, and being used to power a tool that essentially enable facial recognition. And in that situation, you could tell that the ICO was going to go hard. And in fact, the company that was originally fined appealed. The first tier tribunal sided a little bit with this company, saying, well, it's not really breaching the law in the UK, but then it was appealed by the ICO, and then the Court of Appeal sided with the ICO. So you see a regulator enforcing the law, pursuing the law through the courts. At the same time, we know from loads of investigations that we have dealt with the ICO, where if you approach that investigation in a collaborative basis and you show that there is substantial work in progress enabling compliance with the GDPR, the ICO will play good cop and will do that. And other regulators have done so. If there are examples, for example, of the Irish Data Protection Commission negotiating a way forward last year with LinkedIn, dealing with the use of data from their own networks for the development of AI. And the companies provided some commitments around transparency, around legitimacy, around subject rights and data subject rights in general. And the Data Protection Commission didn't take enforcement action in the sense of investigating further or imposing any kind of monetary penalty, but it did get the outcome that it wanted. So you can see this combination of approaches of bad cop, good cop, all around the same type of issues, which are to do with legitimacy and data minimization and transparency, and the core aspects of the GDPR as they apply to the development and the use and deployment of AI.
Eduardo, that's kind of really interesting, that dynamic, and does seem to kind of create a strategy around, how organizations can start to both develop and use AI, and think about, well, what is it that they need to do during the process of those early stages, whether it's in development or adoption, about how they manage those. And I know, from speaking with you, very clear ideas about how to manage things like AI governance, to try to anticipate where the concerns would be, and then to show that those concerns were reasonably addressed right from the very beginning, not something that's being brought as an afterthought. Has that been a dynamic that you have seen as part of your correspondence and your work with these DPAs in these enforcement matters?
100%, 100%. In every investigation we've been involved, whether again it was more on the good cop side of things, of a regulator being friendly, or more or a harsher approach, invariably regulators are asking about practices, and possibly the first question is, show us the data protection impact assessment that you undertook in relation to the processing of personal data in this particular context. Again, both in relation to the development of AI and the implementation of AI, particularly if AI is used, say, to make decisions that affect people. So that regulatory expectation, that if you are doing these very novel things with this technology, again, even if you are developing it, but also if you are using it for your core business purposes, the expectation is that you have thought about how to comply with the law. And as Julia was saying, this is no longer a surprise, or it shouldn't be a surprise anymore, because regulators have been consistent. in Europe and outside Europe, we've seen, for example, the Brazilian Data Protection Authority taking action in relation to compliance. And in the same way, we are familiar with the European concepts that I was referring to earlier. The Brazilian authority was assessing compliance and the undertaking by the company of all these measures, these compliance and accountability measures, showing that they have thought upfront how to comply with the law. So enforcement is very much driven by an expectation of accountability and responsibility at the moment.
Yeah, and I think another interesting point, that came up from our exchanges with DPAs in this space is that they really need to be educated and they really need to learn about the specifics. So my feeling is like many times, at least the Italian Data Protection Authority tends to approach any generative AI, whereas this is not the case, right? Especially in a space where there's a lot of startups or small companies, sometimes developing very sophisticated AI technologies, other times just relying on, solutions that have been developed starting from third-party models. So any situation is different. And I think, especially with all the technicalities that are inclusive and are relevant to the processing related to these new technologies, it's really important also to educate regulators to make them understand that, okay, you're applying, data protection legislation by the book, but perhaps there are substantial differences that need to be taken into account.
Yeah. And maybe if I'm thinking about this, we could say, data protection, we can call GDPR, but obviously those are themselves very big topic. It's not like the GDPR says one thing, it's a sentence long and we're all done, right? The GDPR by itself is a complex, comprehensive set of regulations that requires many things. Any areas around, the efforts around accountability that Eduardo was describing, but issues surrounding transparency and lawful basis and data subject access rights, like a bunch of different aspects. So as you're teasing out and thinking about, well, how does a regulator, how does one of the DPAs that you've seen in these existing enforcement actions approach the application of GDPR on AI? What are those specific components of the GDPR that they're focused on? So, for example, are they focused on kind of lawful basis with respect to training data? Or are they focused mostly on kind of the notice issues around how individuals feel like their data is being included, sensitive data? My guess is that list goes on and on. Any themes that you would want to share kind of with our audience?
I think all of that.
All of it.
Go ahead.
Yes, I think let me give you a couple of examples. Lawful grounds is the basis for the processing of personal data. So almost an existential question in the context of the development of AI is, if a company is essentially obtaining this massive amount of data from the internet, which will include personal data, and maybe personal data is very small proportion, but still in the whole scheme of things, we're talking of a vast amount of data. And the question is, okay, so what is the legal basis for the processing of this personal data? There was a time that perhaps there was a debate about it. The debate is over. The answer is legitimate interest, because you're never going to be able to get people's consent for the data that exists on the internet, or rely on any other legal basis under Article 6 of the GDPR. So it's legitimate interest. The question is, how do you then meet the legitimate interest test? And again, regulators have been very adamant to apply existing law and existing case law, saying, okay, well, you need to follow that three-step approach to legitimate interest, and making sure that the interest is indeed legitimate. That then isn't necessary. And then when you balance it against the rights of individuals, that potential privacy intrusion doesn't undermine the rights of individuals. So all of that is going to have to be shown to a regulator that is asking those questions. And if you don't have a legitimate interest assessment ready-made, then you better put one together very, very quickly, because I can tell you that a regulator is going to be asking for that. Another example, of course, is transparency. Transparency, which in a sense is such an obvious data protection requirement. Again, when you are collecting all this vast amount of information, how can you prove if you told people, by the way, you know what, we may use your data in order to develop AI? Nobody has been told about it, or at least until a couple of years ago, no privacy notice ever said, we will use your personal data in order to develop AI. They were silent. So the question is, how do you then overcome that lack of transparency and ensure compliance with the law? And again, the regulators enforcement shows that regulators expect companies first today to put something in their privacy notices regarding that use of data, but more generally to spread the word saying we are an AI company, and by the way, here's a blog, or here's some public announcement about how we use personal data and whose personal data we may collect and on what basis and so on. So there you have a couple of sort of basic requirements where enforcement is showing that compliance is expected. And I'm sure Julia has even more juicy examples of provisions in the law that need to be complied with in a similar way.
Yes, and I think this you mentioned, Eduardo, when we supported back in 2023, the blocking order of the Italian DPA came out. All the negotiations was exactly about these topics. So I think it's also fascinating because as it happens, this is a space where enforcement is just helping creating compliance, right? As it happens with all new technologies. Another area where I'm seeing a lot of attention is data subject rights. So regulators are really expecting for data subjects to be able to submit the request and see the request is followed up. And then obviously it may not always be easy or feasible to actually enforce that request, because identifying, for instance, a specific information within the training data set may not be technically possible. But the important thing is just to, have processes and be able to demonstrate that there is a procedure supporting that request. And there's another very hot and sensitive topic related. I mean, it's a general trend, but with AI, we're seeing a lot of attention on that is minors. So, make sure that there are adequate safeguards to avoid the data processing of minors, or for generative AI services, that there are specific versions of that service that are suitable for minors and meet specific standards. And this is a topic that covers is not only specific to data protection, is one of those topics that is relevant also under other pieces of legislation. And I think there's no clear-cut and shared solution yet. So there's still a lot of reasoning around this point, but certainly it's an area where attention needs to be super high.
Yeah, and I'm interested maybe in kind of other aspects of what you're seeing on that point, Julia, because that's a trend that certainly we see here in the United States, that there is a lot of focus with respect to the protection of minors, the protections of minors on social media, the protection of minors in connection with chatbots, and I think there is a wide concern around how legislation can be crafted in a way that is going to be designed maybe not to regulate all AI, but to regulate aspects of AI that are going to have a specific aspect with respect to minors. And as you just pointed out, it's not really about the GDPR or data protection, although there are themes of that come in when you're talking about data, sensitive data, but it is much more around consumer protection, perhaps. And interested on, if you're seeing other aspects of consumer protection law start to play out in connection with AI technology, or perhaps even other areas of law that are going to be relevant to AI enforcement activity within Europe or in the UK. maybe Eduardo, I can ask you to get started on that question first.
So I think, just for example, to link this to the issue of minors, this is an example where perhaps we've seen regulators across the world, certainly in Europe, but also in the Americas, like the Canadian privacy commissioner, and again the Brazilian, but also in Asia, like the Korean authority, very focused on the protection of minors and the investigations that emerge very quickly across all these jurisdictions as a result of the use of grok to create explicit sexual images of people, including, of course, children. That is possibly the most sensitive type of AI use I've seen, even beyond facial recognition, because again, you are talking of protecting individuals from it goes beyond data. It's about protecting people's lives from a, you could say it's consumer protection, but it's about anyone on the planet, particularly the most vulnerable. So you see that, and interestingly, of course, it is in those situations where regulators who normally operate in silos start to operate in a much more coordinated fashion. The UK is a really good example where you have, of course, the Information Commissioner's Office dealing with this, but also Ofcom, which is the regulator of means of communication like the internet, but also the competition authority that, of course, deals with anti-competitive practices, all collaborating under the banner of an organization that was actually created for that purpose of cooperation, called the Digital Regulation Cooperation Forum, that is precisely aimed at ensuring that all these actions that are happening in relation to any new technology, but principally AI, are addressed with all these regulators coordinating their opinions and their actions, so that, yes, each of them will act within their sphere of competence, and otherwise they will be challenged, but ultimately they will agree. And whilst all of them are trying to set out their credentials as being pro-innovation, they are also pro-protection. And we are going to see that more and more. And it's interesting that, in a way, we don't have any AI specific laws that enable this, but it's in fact existing laws and a coordination mechanism amongst the regulators that enables this type of enforcement.
Yeah, and in Italy, and I mean, I'm happy to hear this because in Italy is kind of a schizophrenic situations. There are so many draft laws addressing the topic of minors' consent, parental consent, with regard to different areas. So with regard to the access of video sharing platforms, with regard to the minimum age for providing consent for data processing purposes. And overall, what we're seeing is a tendency to have a very conservative approach, because as you said, Eduardo, I think there's this feeling that it's not just a matter of legal regulation, it's a matter of protection of underlying values of a culture and a society. And I think the two legal layers where we're seeing regulations is, on the one hand, efforts to regulate under data protection legislation. We know this may be hard to some extent because the provisions of the GDPR are just with regard to the situations where minors can provide their consent when it is required as applicable legal basis. And then there's a contractual dimension. So a lot of the draft laws we're seeing in Italy are aimed at kind of regulating the circumstances where minors can validly execute contracts in the information society services, or to access social media platforms and so on. I think it's a moment of chaos right now, because there are kind of different tendencies. So on the one hand, there's this tendency to regulate these aspects in a very conservative way, and on the other hand, there's awareness that, as Scott, you correctly said, it would be nonsense to put an overarching requirement with regard to access and use of AI technologies. And on this, it's really interesting because on the law that in Italy implemented the AI Act, there's a very odd provision that basically would seem to require or to impose parental consent requirements with regard to the access and use and processing of personal data of minors for any AI technology. And that would be very odd if you think about that, because there's very different AI technologies. So we're not just talking about vocal assistants or high-risk AI systems, but there may be also AI embedded in toys or AI embedded in products that are normally available to minors. So this is certainly one space where I believe time is not ripe yet, and we really need to come up with strong solutions to find the right balance in between the different interests.
Yeah, I mean, that's fascinating, Julia. And, I think one of the things that I should be taking away, and what I think all of our audience should be taking away, is that, yeah, sure enough, like there's a lot of enforcement activity in Europe and in the UK on these issues, and it's diverse and it's coming from a variety of different legal perspectives, none of which are yet the EU AI Act, which I want to come back to in a moment. But before we do that, can you give just a quick sense? What is the existing remedies that the enforcement authorities are looking for? Are you seeing fines, penalties, kind of other types of enforcement that remedies that regulators or litigants are seeking?
Yeah, so I think in terms of enforcement trends, what I'm seeing is a lot of recourse to urgent measures. I think more than in any other times or space with regards to AI or generative AI, we're seeing a lot of recourse to urgent measures. So this is perceived as something that is worth being protected fast and even bypassing the normal guarantees you would have in a normal, administrative or sanctioning procedures.
What's an urgent measure? I'm not sure that is a term that's used in the United States, for example.
Yeah, so that would be, an order, an injunction issued on an urgent basis. So basically, without notifying the opening of a sanctioning proceedings, because there's evidence that a specific activity is posing an harm that is severe and risks to have very detrimental consequences. So needs to be stopped on an urgent basis. And on the other side, the remedies or the enforcement outcomes we're seeing are certainly sanctions. So sanctions in terms of fines, monetary penalties, and also orders in terms of adopting specific measures that ensure the compliance with the requirements set forth by the GDPR, and sometimes even beyond the GDPR. Because I believe to kind of fill in the gaps of those existing loopholes, as long as they were loopholes. So as Eduardo said, legal basis. It's even fun to think about. 3 years ago, we were debating, is legitimate interest right or not? Now there's also the proposal on the digital omnibus that recognizes legitimate interest as legal basis for use and development of AI, subject to specific guarantees. But over the last years, in order to support the suitability of this legitimate interest as legal basis, many regulators had issued decisions requesting specific additional measures. So not measures that guarantee the bare minimum compliance with GDPR, but additional measures in terms of enhanced transparency. Like the Italian DPA ordered some providers of AI to adopt, in addition to the privacy notices as per Article 13 GDPR, also awareness campaigns, or to go on TV or radio to explain and educate people about generative AI, about data processing for AI training, about their rights. So this, in a way, is kind of a more creative approach, but is linked to the need to create a strong basis.
But if I may add, I think these measures are really important in the sense of adding them to the enforcement mechanisms that we have. Perhaps the ultimate enforcement mechanism is a suspension of a particular operation. And we've seen regulators, again, across all continents, ordering companies to, at the very least, temporarily suspend their operations. So when you are a business, and yes, you may be able to swallow a fine or some other kind of penalty, or you may be given the opportunity to adopt some measures over a period of a few months. But when you are told, as of today, you can no longer operate and you can no longer do what you are doing in our jurisdiction, that is a very severe measure, and we've seen that happening.
Eduardo, I mean, that's really important to make sure you're highlighting. And like, I think the whole idea of what does recourse look like? What is it that organizations should be thinking about in terms of what penalties are on the horizon here? It's just its own area of debate, because it's not so clear kind of what it is that regulators or governments would expect. So for example, Julia, your descriptions of like, doing a public awareness campaign was fascinating, here in the United States, at least under the prior administration, and likely to take to hold in other jurisdictions as well, including at the federal government, if there's a change in administrations in the future, is like a fruit of the poisonous tree theory. It's like, you created an artificial intelligence system. You did that unlawfully. You don't get to have that system anymore. You have to delete it. You have to destroy it, which you can imagine is a much more severe remedy than just paying, whatever the amounts are. But from a policy perspective, it's not even clear that that's the right solution, because, suppose you created technology for allowing autonomous vehicles, you violated all sorts of privacy rights in doing so. The knowledge, the system that was created, has nothing to do with that personal data that was originally processed, and it has all sorts of great value for the world, but yet we're going to say that you have to destroy it. And it's just kind of a fascinating dynamic, which maybe we should talk about in a future episode. And I know time is short, so I want to make sure I ask maybe one last question of each of you. And maybe, Eduardo, I'm going to ask you, we've talked a lot about what enforcement looks like today, and it's robust, it's varied, it's coming under a lot of different existing legal theories. We are soon going to find our world where we will have a specific AI law. And I'm very interested in your perspective on what does enforcement look like under a future enforceable EU AI Act and the equivalent in other jurisdictions. And then, Julia, maybe if I can ask you to add to Eduardo, as you're thinking about where does the rest of the enforcement look like outside of the EU AI Act? Are we still going to expect it's the EU AI Act plus other things as it is maybe today? Eduardo.
Well, we are already seeing up to an extent a degree of enforcement under the EU AI Act, because of course there are elements of the EU AI Act that are not operational yet, and we'll find out in a few months whether they become operational this year or later. But of course there are elements of the AI Act that have been operational for, in some cases, just over a year or just under a year. And what we've seen is that whilst the bits of the AI Act that are yet to come into effect will be subject to a more diversified level of enforcement, and by that I mean more local authorities and regulators taking control. The bits of the AI Act that are already in place are essentially enforced by the European Commission, by the AI office, to be more precise, within the European Commission. And what we saw was that this time last year, as the bits of the AI Act that were due to come into effect were in that process, the AI office was very much playing the role of, we're here to help, please ask us questions, we are here to engage. And in fairness, they've been doing that over the past year. Comes 2026, with some of the general purpose AI model provisions already in place, and they've been in place for a while, and the code of practice. What we've seen is the AI office, at the very least, pushing back on some of the ways in which companies were trying to comply with the code of practice of the general purpose AI models. And again, not in a very aggressive way or threatening way, but in a way that the AI office is saying, look, we are here to ensure that everybody complies with the law in the same way and in a valid way. We are here, and Julia was referring to the importance of regulators understanding how the law, not just the law, but actually the technology works. And the AI office is very good at that, but they are also very good at pushing back and say, you need to go a bit further in explaining how this technology works or how to comply with this particular aspect of the code of practice. And we are seeing that, and it's early days, but rest assured that regulators will enforce the AI Act as it evolves.
Yeah, I think there's one word that is key, that is coordination. We are seeing more than ever under the AI Act, there's a multitude of, regulators that are going to enforce. As Eduardo said, that there's this double layer of AI office and local regulators. There's efforts in the digital omnibus to simplify and create, a parallelism with the Digital Service Act, so to recognize more competence to the AI office, I think, in the effort to create more consistency in the existing digital legislation framework. I think there's the need of a leap of faith, or at least on the regulator side, a big effort to create actual room and spaces for them to interact, to create shared views, to make sure they take common stances and they have a general understanding and they avoid gold plating. I was speaking with someone from the Irish Data Protection Commissioner 1 year ago. They set up a dedicated function for monitoring inter-authority cooperation and enhancing positive cooperation with other authorities and within departments within the data protection commissioners. So I believe this is the way to go, because if you think about legislation, then we can have the best legislation in the world, but then the real game is played on enforcement. So if when it comes to enforcement, we have very different views, very different interpretations, very different approaches and styles, then harmonization under EU law is never going to be met. And I think GDPR is a very good lesson to look at, because GDPR as one-stop shop, and in practice, we have seen it worked well for under a certain perspective, but still we haven't avoided different interpretations and different styles. So I think this is really important to work towards this direction.
Yeah, I 100% agree with that. Well, this has been a great conversation. There's so much content here. I feel like we could probably go another couple of hours to try to dissect each one of them. So we may need to start to do a regular, look in as to some of these enforcement matters. But in the meantime, I think this overview really gives our audience a sense of the depth of activity in the EU and the UK, which I think is clearly significant, and then perhaps what it is that can help guide our organizations and our clients as they work to develop, adopt, and innovate in AI, but also in a way that's going to protect them from the risks that we're all discussing today. So thank you both.
Thank you.
With that, I'm Scott Lachlan. This is the Data Chronicles, and those were your data points.